Good evening, black people and all allies fighting for black liberation, black prosperity, and black joy. I'm Charles Blow, and welcome to Prime. Prosecutors and defense attorneys delivered their closing arguments today in the trial of 3 white men charged with murdering Ahmaud Arbery last year. The defense maintained that Gregory McMichael, Travis McMichael, and William Roddy Bryan acted out of self-defense and had a right to make a citizen's arrest. Even though Arbery was unarmed, one of the defense attorneys argued that he was not an innocent victim.
Turning Ahmaud Arbery into a victim after the choices that he made does not reflect the reality of what brought Ahmaud Arbery to Satilla Shores in his khaki shorts with no socks to cover his long, dirty toenails.
The defense attorney for William Bryan tried to distance his client from McMichael's and argued that Bryan acted in good faith by jumping in the McMichael's car while they chased Arbery and by recording the killing on his cell phone.
I would submit to you that you can call it karma, you can call it fate, I would call it divine providence. Somebody is guiding Mr. Bryan, whether it's a conscious thought process or not. Something is guiding Mr. Bryan down this street to document what's going on.
The prosecutor, on the other hand, told the jury the defendants cannot legally claim self-defense because they were the aggressors. For the first time in this trial, the prosecutor argued that these three men attacked Arbery because he's a black man.
They made their decision to attack Ahmaud Arbery in their driveways because he was a black man running down the street.
The prosecution will finish its closing arguments tomorrow morning, after which the jury will begin deliberations. Now, in another white vigilante case, Kyle Rittenhouse, the 18-year-old who was acquitted of murder last week after fatally shooting 2 people at a Black Lives Matter protest last year and injuring a third, had a lot to say about race in an interview with Fox News.
This case has nothing to do with race. It never had anything to do with race. It had to do with the right to self-defense.
Right.
I'm not a racist person. I support the BLM movement. I support peacefully demonstrating.
Joining me now to discuss, Charles Coleman, former prosecutor and defense attorney, and C.K. Hoffler, chair of the Rainbow Push Coalition and former president of the National Bar Association. Mr. Coleman, so I just want to know what you make of the closing arguments in the Ahmaud Arbery murder case.
Well, what we saw today, Charles, was just a flat-out Hail Mary at 2 things. Legally, I think the defense attorneys were attempting to create whatever issues they could with regard to being able to preserve a record for a potential mistrial, or a potential appeal in the future because the mistrial wasn't granted. I also think that the defense attorneys have decided in unison, in tandem, that they are going to put down the dog whistle and pick up the bullhorn with respect to trying to trigger something that is latent or within some of the jurors by hitting on old racial tropes and stereotypes. When you heard the attorney for George McMichael give her summation today, what you heard her do effectively was essentially describe Ahmaud Arbery as a runaway slave. And it was difficult to listen to, but consistent, because this trial, from the actual actions of the 3 defendants all the way through to the actions of the attorneys for those defendants, has been wrought with overtones of white entitlement. And you saw full-fledged on display today. But I do think that the prosecution has a good chance tomorrow on rebuttal to call it out for what it is. But the key is that everyone there has to understand their audience. That may not play very well in front of the jury. And so I think the defense attorneys took a gamble in terms of how they approached the conversation today. And it will be interesting to see how deeply the prosecution probes that on their rebuttal tomorrow.
CK, let's juxtapose that racial dog whistling or maybe bullhorning, as Charles was just describing, to the prosecution's case, which has avoided to a large degree the issue of race, didn't really bring it up during the trial, just brings it up, just in a passing way. They didn't stay on the issue of race. They just brought it up at one point during their closing. What do you think of that as a strategy in this case?
Well, Charles, what I think of it as a strategy is they were in it to win it. They have a jury that's comprised of 11 white folks and 1 black person. So to make race a big issue may be ill-advised with that jury, although we know race is dominant in this case, is why there was a murder, is why it happened. It's because of race. But they're playing to a jury because they're in it to win. And they know, I believe the prosecution understands quite clearly where she is, where this is happening, and what's going on, and feels that she just needs to mention it, impose the thought, put it out there, but not dwell on it, because she's got to give these 12 jurors some other reason, some justification, some legal basis for convicting all 3 of these defendants that, by the way, doesn't have to deal with race, only because she's looking at her jury. So I think it's a strategy calculated to say, look, we know what it's about. You and I know what it's about, but let's just put that aside, because even if you don't see that, how about look at all these other things? This 1863 law, quote unquote, citizen's arrest. Well, you can't have a citizen's arrest if there's no crime that's being committed. Ahmaud Arbery was not in the process of committing a crime. Dissecting the legal argument so that that goes out the window. And once that goes out the window, of course, self-defense has got to go out the window, because you trapped him, in your words, like a rat. You chased him down like a rat. And the notion that Mr. Bryan's lawyer would say, no case without the gratuitous philanthropic acts of my client, there would be no case. Well, there would be no case if your client didn't also act in conjunction with the other 2 defendants to trap Ahmaud Arbery, hunt him down, and position him to be murdered. Yeah, there would be no case if he didn't do that.
Right.
But to say that out of the kindness of his heart, he turned over the video is insult on top of insult, offensive, reeks of racial animus, but very consistent with Mr. Goff's behavior.
So, Charles, we saw the defense attorneys trying to distance themselves, at least Bryan's attorney trying to distance themselves from the McMichaels, right? To say, they may have done a horrible thing, but not my guy. Do you think that this is a strategy that all 3 will play, even the McMichaels attorneys themselves? Did you think that that was happening? Because, maybe they're trying to get the jury to focus all their, guilty inclinations on one person rather than all 3, to try to cleave them apart. Do you think that that was happening? How effective do you think that was today?
Well, I predicted this once I saw how the prosecution's case was unfolding, and then especially after I saw Travis McMichael get absolutely eviscerated on the stand during his cross-examination. I anticipated that the defendants were going to begin pointing the finger at each other. Now, I didn't think it was likely that George and Travis McMichael as family were going to be pointing the fingers at each other, but I did anticipate that Bryan was going to try to separate himself and basically sort of get on a every man for himself program at that point. And that's exactly what's happened. What I can tell you, Charles, and for other viewers, is that when that happens, when defendants begin to start pointing the finger at each other, typically that does not look good in front of juries, and everybody goes down, because very few people are trying to parse out the difference between sort of the old meme of Spider-Man pointing at Spider-Man and saying, you, no, you, no, you, no, you. And so ultimately, I think what's going to happen is that the jury, if they're paying attention, is going to see that and basically decide everyone's guilty. So while I did anticipate it, it's not a good sign for any of the defendants.
CK, let's shift cases to the Rittenhouse case. And now he's going on Fox News and saying, I'm not a racist, I support BLM, this is all about self-defense. The jury has said what the jury has said. However, what are your thoughts about this? Do you have to be a racist to benefit from a society that has racial biases embedded in its systems? Do you have to say that I am a raging, bigot in order to get the benefit?
No, you don't, because the reality is your actions speak louder than words. So you can say whatever you want to say, but it's your actions that determine what is and what isn't. He injected himself, and the jury has spoken, and I respect the jury speaking. I respect the verdict, and that's what it is, period, in the discussion. Can't change that verdict. But the reality is he did inject himself in a Black Lives Matter protest. It wasn't a boop boop de doo protest. It was a Black Lives Matter protest. And he felt that he needed to inject himself in there to ostensibly, with an assault weapon, protect property. And he shot and killed 2 people and injured a 3rd. So you don't have to say it's like you protest too much. It is what it is. And I don't think simply because you say that you're not a racist, I think actually most people who are racist and who are white supremacists don't believe that they're racist or white supremacists. They believe that they're justified in what they're doing. And they don't label themselves as racist. They label themselves as people who are in favor of whatever cause they're into.
Charles,
Charles, what do you think about the way that Rittenhouse is being valorized in all of this?
Yeah, if I may, what we know from having watched Kyle Rittenhouse on the stand is that Kyle Rittenhouse's understanding and level of sophistication, and I don't mean this in a pejorative way, simply is not at a level where he is qualified to disqualify himself as a racist in terms of understanding what that is. Now, he may believe that he does not harbor discriminatory animus or bigotry toward any particular group, and it's not my place or anyone else's to say what is in his mind or his thoughts. But I think that there is a level of privilege that he enjoyed that is connected to his color and who he is and how he shows up that he simply may not even be aware of at this age if he ever does become aware of it. And I think that that's important to understand. He may not even understand that the way that this trial played out, the way that he even got to trial has everything to do with race. And he will not understand that if his name was Kyrie Richardson and he had come from Newark, New Jersey to Brooklyn, New York with a firearm for the purposes of protecting businesses amidst a BLM rally, he likely would have never made it to trial, let alone being acquitted. And so to say this had nothing to do with race, race is not a factor, in and of itself is demonstrative of his lack of understanding of the totality of these circumstances where race is concerned.
Charles Coleman and C.K. Hoffler, thank you for joining me tonight. I appreciate both of your time.